The family courtroom in Philadelphia felt colder than the winter air outside. The fluorescent lights buzzed overhead, casting a flat, merciless white glow across the wooden benches and the worn carpet. I sat at the respondent's table, my hands folded tightly in my lap, forcing myself not to look at my daughter Haley in the back row. Her small legs swung beneath the seat, innocent and out of place among all the tension. Across the aisle sat my older sister Alexandra, spine-straight eyes fixed forward with that calm certainty she always wore when she believed she was right. Her attorney, Mr. Daniel Reed, rose smoothly and addressed the judge. "Your Honor," he began, voice steady, and measured the facts. "Here are straightforward. The respondent is broke, unstable, and unfit to be a mother. She has no verifiable employment, no fixed address, and she disappears for weeks, sometimes months at a time, leaving her child in the care of extended family without explanation or contact." He paused just long enough for the words to land. The courtroom went still. A few heads in the gallery turned toward me. Alexandra didn't move, but I could feel her gaze shift sideways, satisfied, like someone who had already won. I stared at the table in front of me. The phrase "broke, unstable, unfit mother" echoed in the silence, sharp and final. My lawyer shifted papers beside me, but I knew he couldn't say much yet. The truth. The real reason for every absence, every missing paycheck, every change of address was locked away in places no one in this room was allowed to open. Not yet. If you've ever watched someone you trusted turn against you in the worst possible way, especially when a child is caught in the middle, stay with me. What happened next changed everything. Have you ever been betrayed by your own family in a custody fight? Drop a comment below and share your story. I read every one. Let's talk about it. P2. Her attorney kept going, his tone even and professional, like he was reading from a script he had rehearsed in front of a mirror. "She has no stable employment history that appears in any public record," Mr. Reed said, gesturing toward a thin stack of printouts on his table. "What income she claims comes from sporadic freelance work, erratic payments that don't show up consistently on tax filings or bank statements. Addresses change every few months, always listed as temporary or care of locations. And then, there are the absences." He let the word hang for a moment. Multiple periods, weeks, sometimes stretching into months, where my client's sister was completely unreachable. No phone calls returned, no emails answered, no way to know where she was or when she would return. During those times, Haley was left in the care of my client and other extended family members. My client stepped in willingly each time, providing a stable home routine, school transportation, everything a child needs. He turned slightly toward the judge, voice lowering just enough to draw attention. "To prove the point, we have recordings of several phone conversations. In one from last spring, Haley can be heard asking when her mother would be home. The response was vague, soon, followed by silence on the other end. Another call. 2 months later, Haley simply said, 'Okay,' and hung up after 30 seconds. No explanation, no reassurance. These are not isolated incidents. They form a pattern." I felt my stomach twist. I remembered every one of those calls. The hotel rooms with thin walls, the burner phone on the nightstand, the clock ticking toward a meeting I couldn't miss. I had wanted to tell Haley the truth. Mommy's doing important work. Mommy will explain everything when it's safe, but the rules were clear, no details, no promises that could be traced. So I said soon, and the line went quiet, and I sat there afterward staring at the ceiling until dawn. Mr. Reed continued without pause. "My client has been the constant in Haley's life during these gaps. She attended every parent-teacher conference when the mother was unavailable. She drove to school plays and sat in the front row alone. She organized birthday parties, bought gifts, made sure there was cake and balloons. Haley's teachers know my client's name better than they know mine." He placed one hand on the table, fingers spread. "And there is more at stake here than just day-to-day care. Haley is the beneficiary of a trust established by her grandparents, my clients, and the respondent's parents. The trust includes funds earmarked for education, a college savings account now valued at over $150,000, and a separate inheritance provision that becomes accessible when she turns 18. Under Pennsylvania law, if a parent is found to have engaged in prolonged neglect or abandonment, the court may appoint a guardian of the person and estate. My client is prepared to serve in that capacity, ensuring the funds are used solely for Haley's benefit and not dissipated or mismanaged. The judge made a small note. I saw her pen move across the yellow legal pad. Mr. Reed's voice stayed level. This is not about punishing the respondent. This is about what is best for the child. Stability. Consistency. A home where someone answers the phone when she calls, where someone shows up for the important days. My client has provided that for years. The respondent has not. I kept my eyes on the grain of the table. The wood had tiny scratches, probably from years of nervous fingers tapping. I thought about the nights I had lain awake in safe houses listening to traffic outside, wondering if Haley was asleep or crying into her pillow because Mommy didn't call back. I thought about the debriefings, the non-disclosure agreements the moment my handler handed me a new ID and said, "You're dark for the next 8 weeks. 0 contact." I had signed every time. I had chosen the work. But choosing it didn't make the guilt disappear. Mr. Reed gathered his papers, aligning the edges with precision. Your Honor, the evidence is clear. The pattern of absence, the lack of verifiable stability, the reliance on others to fill the role of parent, these are not the hallmarks of a fit custodian. We respectfully ask the court to consider awarding primary physical and legal custody to my client, Alexandra Harper, so that Haley can have the security she deserves. He sat down. The room stayed quiet except for the soft scratch of the judge's pen. I didn't look up. I didn't need to. I could feel my sister's satisfaction radiating across the aisle like heat from a radiator. She had played her cards perfectly. The recordings, the trust fund, the years of stepping in, she had built a case that looked airtight from the outside, but she didn't know the inside. Not yet. P3. My lawyer rose slowly from his chair. Mr. James Thompson adjusted his tie, cleared his throat once, and faced the bench. Your Honor. He began. The petitioner's presentation relies on incomplete information. There are federal records and circumstances that directly explain the respondent's employment history, residential changes, and periods of unavailability. Those records are not part of the public domain and cannot be disclosed in open court without proper authorization. We respectfully request that the court consider sealed submissions or an in-camera review to address these gaps. His voice carried the careful weight of someone walking on thin ice. He didn't elaborate. He couldn't. The non-disclosure agreements I had signed years ago bound him as tightly as they bound me. The judge looked up from her notes, eyebrows slightly raised. Before she could respond, the bailiff approached the bench from the side door. He leaned in and spoke in a low murmur that carried only to her. Then he handed her a plain manila envelope sealed with red wax and stamped with a federal insignia. The envelope was thick edges, crisp, no return address visible. Judge Ellis accepted it without a word. She broke the seal, pulled out a single sheet clipped to several redacted pages, and began to read. Her expression shifted almost immediately, not dramatically, but enough that the lines around her mouth tightened and her eyes narrowed. She turned the page, scanned another, then set the documents down and looked directly at me for the first time since the hearing began. Not with sympathy, not with accusation, just recognition. A woman in a dark tailored suit who had been seated quietly in the last row since the session opened rose without hurry. She had been there the entire time, notebook open on her lap, pen moving in short, deliberate strokes. No one had paid her much attention. She blended into the gallery like furniture. Now she walked down the center aisle with measured steps, heels clicking softly on the tile. She stopped at the rail, placed a slim leather portfolio on the edge of the bench, and spoke in a calm, professional tone that cut through the hush. Special Representative, United States Department of Justice Protective Programs Division. She didn't raise her voice. She didn't need to. The words landed like stones in still water. Ripples spread a sharp intake of breath from the gallery, a rustle of papers from Mr. Reed's table, the faint creak of my sister's chair as she shifted forward. The judge nodded once, acknowledging her presence. Proceed. The woman her badge identified her only as Agent Caitlin opened the portfolio and slid a single credential card across the bench, followed by a sealed affidavit. These materials are classified under federal protective statutes and are submitted for in-camera inspection only. They pertain to the respondent's participation in a federally authorized confidentiality program. Disclosure in open session would compromise ongoing operations and individual safety. Alexandra's hands tightened on the arms of her chair. Her knuckles went white. She glanced at her attorney, then back at the bench, lips pressed into a thin line. For the first time since the hearing started, she looked uncertain. Judge Ellis examined the credential longer than necessary, then flipped open the affidavit. Her eyes moved quickly across the blacked-out sections and the few visible lines. She paused at one paragraph, reread it, then closed the folder with deliberate care. The air in the room felt thicker, charged. No one coughed. No one shifted. Even the bailiff stood motionless beside the door. I kept my breathing even. I had known this moment might come eventually, but not like this. Not in front of my daughter, not with my sister watching. The program had rules: minimize exposure, maximize deniability. Yet here we were, the envelope on the bench, like a bomb that hadn't yet detonated. Agent Caitlin remained standing, posture straight, but unthreatening. The information contained herein confirms that the respondent's absences and financial irregularities are consistent with participation in a protected federal initiative. Further details require controlled access. I am prepared to answer any questions the court may have in chambers. Mr. Reed stood halfway, then sat again. His mouth opened closed. He looked at Alexandra, who stared straight ahead, jaw set. My lawyer stayed seated, silent, letting the moment breathe. The judge tapped her pen once against the folder. Counsel, we will recess briefly to review this submission in chambers. The gallery will remain seated until further notice. She rose. The bailiff called all rise. Everyone stood as she disappeared through the door behind the bench, envelope in hand. The room exhaled. I didn't move. My daughter's small shoes stopped swinging in the back row. I could sense her watching me, confused. Alexandra turned her head slowly toward me. Our eyes met for the first time that morning. Hers held something new, not triumph, not anger exactly. Fear, maybe. Or the beginning of doubt. I looked away. P4. Judge Ellis closed the folder with a soft snap that echoed in the sudden quiet. She placed it flat on the bench and looked out over the room. This submission contains sensitive federal material, protected under confidentiality statutes, she said. To safeguard the information and prevent any risk of unauthorized disclosure, the court will now clear the gallery and the press. All spectators and members of the media are to exit the courtroom immediately. Only the parties' counsel and necessary court personnel will remain. The bailiff stepped forward without hesitation. All rise for the court's directive, he announced, though no one had been seated long. Chairs scraped against the floor as people stood. A low murmur rose from the back rows, confusion, curiosity, a few disappointed sighs. Reporters folded their notebooks, photographers lowered cameras, and ordinary observers gathered purses and coats, glancing toward the bench as if hoping for more explanation. The bailiff moved efficiently down the aisles, guiding people toward the double doors. One woman in the third row hesitated, whispering to the man beside her. The bailiff touched her elbow gently but firmly. "Ma'am, please exit now." She complied, the door swinging shut behind the last of them with a heavy click. The room shrank. What had felt crowded and public now held only the essentials: the judge on her elevated seat, the court reporter at her machine, the clerk at the side table, my lawyer beside me, my sister and her attorney across the aisle, my daughter still in the back row with a social services observer who had been assigned to monitor her during the hearing, and the agent standing near the rail. Alexandra remained seated, her posture rigid. She did not rise with the gallery. Neither did Mr. Reed. They were parties to the case, petitioner and counsel, and the order did not apply to them. But her face had changed. The calm assurance from earlier was gone. Her eyes flicked between the judge and me, wide with something that looked like alarm mixed with fury. Her fingers gripped the edge of the table so tightly the skin over her knuckles turned pale. Judge Ellis waited until the doors were secured and the bailiff returned to his post. She addressed the agent directly. "Agent Caitlin, the court will conduct the remainder of this review in chambers. You may present the protected information there. Counsel for both sides will be permitted to attend along with the parties. The child will remain in the courtroom under supervision of the assigned observer." My lawyer stood. "Your Honor, may I request that the respondent be allowed to..." "Denied," the judge said quietly but firmly. "The material is sealed for cause. We proceed as ordered." I felt my pulse in my throat. Chambers meant private, no transcript unless requested, no public record of what would be said. It also meant my sister would hear whatever the agent chose to reveal or chose to withhold. The judge rose again. "We will reconvene in my chambers in 5 minutes. Bailiff, escort the parties and counsel." She disappeared through the side door. The bailiff motioned for us to follow. My lawyer placed a light hand on my arm as we stood. "Stay calm," he murmured. "This is the turn we needed." Across the aisle, Alexandra rose slowly. She smoothed her skirt with shaking hands, then looked straight at me. Her expression was no longer triumphant. It was raw confusion, anger, a flicker of betrayal that mirrored what I had felt all morning. She opened her mouth as if to speak, then closed it. Mr. Reed touched her elbow, guiding her forward. We filed out in a small procession, the agent first, portfolio under her arm, then the judge's clerk carrying the sealed folder, then my lawyer and me, then Alexandra and her attorney. My daughter stayed behind with the observer, her small face turned toward us as we passed. I wanted to stop to kneel and tell her everything would be okay, but the bailiff kept the line moving. The hallway outside the courtroom was narrow and dimly lit, lined with closed doors and framed portraits of past judges. The bailiff led us to a door marked "Chambers, Judge Ellis." He knocked once, then opened it. Inside was a smaller space, book-lined walls, a large desk, and a conference table with 8 chairs. The judge was already seated at the head. She gestured for us to sit. The agent took the chair closest to her. My lawyer guided me to the left side of the table. Alexandra and Mr. Reed sat opposite. The door closed with a soft thud. The bailiff remained outside. Judge Ellis folded her hands on the desk. "This is now a closed proceeding. No recording, no notes beyond what counsel may take for their own use. Agent Caitlin, you may begin your presentation." The agent opened her portfolio again. She placed a redacted summary sheet in front of the judge, then one in front of each lawyer. She did not offer one to Alexandra or me directly. That was protocol for classified material. The room filled with the faint rustle of paper as everyone scanned the pages. My sister leaned forward, trying to read over Mr. Reed's shoulder. Her breathing was audible, shallow. I sat still, hands in my lap. The air felt thick, heavy with unspoken questions. The only sounds were the turn of pages, the occasional creak of a chair, and the slow, deliberate rhythm of the judge's breathing. No one spoke yet. P5. The agent placed the redacted summary sheet in the center of the table and spoke in the same measured tone she had used earlier. "The respondent is enrolled in a federal confidentiality program administered by the Department of Justice. This program provides protective measures for individuals whose cooperation is essential to ongoing investigations involving large-scale financial crimes and human trafficking networks. Participation requires strict adherence to operational security protocols, including periodic relocation-limited financial footprints and restricted communication. She paused, letting the words settle. The periods of unavailability referenced in the petitioner's filings are not indicative of neglect or abandonment. They are authorized absences mandated by the program to safeguard the participant's identity and the integrity of active cases. During these intervals, the respondent was engaged in protected activities that necessitated complete disconnection from personal contacts, including family members. Contact was prohibited to prevent any risk of compromise. The judge leaned forward slightly. How long has this participation been in effect? Since shortly after the respondent completed her undergraduate degree. Approximately 10 years. I felt a small release in my chest, like a knot finally loosening. 10 years of silence, of vague excuses of watching my daughter grow through photos sent by relatives. 10 years of signing forms that said I understood the consequences. Hearing it stated plainly in this room, even with redactions and careful wording, was the first time the weight had been acknowledged by anyone outside the program. The agent continued. Financial and residential irregularities, frequent address changes, non-traditional income streams are deliberate safeguards. Bank accounts are structured through intermediaries, residences are short-term, and unlisted employment records are compartmentalized or covered by fictitious roles. These measures are not signs of instability or insolvency. They are required to minimize traceability and protect against retaliation from subjects of investigation. Mr. Reed shifted in his seat. If I may, Your Honor, this explanation raises questions about verification. How can the court be certain? The judge raised a hand. Counsel questions will be entertained after the presentation. Agent, please, continue. The agent nodded. The program does not permit direct disclosure of operational details, including specific case assignments or locations. However, the sealed affidavit confirms that the respondent's absences align precisely with documented protective requirements. No evidence exists of voluntary abandonment or failure to provide for the child's welfare within the constraints of the program. Temporary care arrangements with family were coordinated to the extent possible without breaching security. My sister's face had drained of color. She stared at the table, lips parted as if she wanted to interrupt, but couldn't find the words. Her hands, which had been clenched earlier, now lay flat and still. The realization was sinking in the case she had built on absences and instability, rested on assumptions that no longer held. The judge turned another page in the folder. Agent Caitlin, does the program include provisions for child welfare or family impact assessments? Yes, Your Honor. Periodic reviews are conducted to ensure compliance with child support obligations and to evaluate the overall effect on dependents. In this instance, financial support was maintained through secure channels and temporary caregiving was arranged with the petitioner's knowledge. The respondent has fulfilled all mandated responsibilities within the program's limitations. I kept my gaze on the table. I remembered the monthly transfers routed through anonymous accounts, the quiet instructions to my sister. If I'm gone longer than expected, make sure Haley has what she needs. I had never explained why. I couldn't. But the money arrived, and the support was there, even if it looked invisible from the outside. Mr. Thompson spoke quietly. Your Honor, this information directly rebuts the claims of unfitness and neglect. The absences were not choices, they were obligations imposed by federal authority. The judge studied the agent for a long moment. Any further questions from counsel before we adjourn this portion? Mr. Reed cleared his throat. Only one. If the respondent's situation is as described, why was no prior notification provided to the court or the petitioner? The agent answered without hesitation. Notification would violate program rules and expose the participant to risk. Disclosure occurs only when compelled by judicial order or when the individual's status is directly challenged in a manner that requires clarification, as it has been here. The judge nodded slowly. Understood. The court will take this under advisement. No further presentation is required at this time. We will return to open session shortly to address next steps. She closed the folder again. The rustle of paper seemed louder in the confined space. Alexandra finally spoke, her voice low and unsteady. This changes things. No one responded. The words hung there unanswered. I felt the first real breath I had taken all morning. The truth had been spoken, not in full, not with every detail, but enough. Enough to crack the foundation my sister had built her case on. Enough to make her see that the absences she had weaponized were not indifference. They were duty. P6. The judge set the folder aside and folded her hands on the desk. She looked first at my lawyer, then at Mr. Reed, then directly at me and my sister. Having reviewed the sealed submission, she said the court finds that the petitioner's claims regarding the respondent's instability, financial unreliability, and parental unfitness are based on incomplete information. The federal materials provided demonstrate that many of the circumstances cited, particularly the periods of unavailability and residential patterns, are attributable to participation in a protected government program rather than voluntary neglect or disregard for the child's welfare. She paused, letting the statement settle into the room. The court cannot at this stage make a final determination on custody without further verification. The submission raises legitimate questions about the respondent's overall circumstances, but it also casts doubt on the narrative presented by the petitioner. To ensure the best interests of the child are fully served as required under Pennsylvania law, the court will adjourn these proceedings pending additional investigation. Mr. Reed straightened in his chair, his earlier confidence visibly diminished. He opened his mouth as if to object, then closed it again. Whatever argument he had prepared seemed inadequate now. He glanced at my sister, who sat motionless, eyes fixed on the judge. Judge Ellis continued. The court will request a supplemental report from Child Protective Services to assess the current living arrangement and any potential impact on the minor child. This report will focus on stability, emotional well-being, and whether the existing temporary caregiving setup continues to serve Haley's needs, while the federal aspects are clarified. The clerk will issue the order today, and CPS will be directed to complete their evaluation within 30 days, unless expedited circumstances require otherwise. She turned to the court reporter. Let the record reflect that the status quo is maintained pending receipt of the CPS report and any further submissions from the Department of Justice. Haley will remain in the current primary physical custody arrangement with the petitioner Alexandra Harper under the supervision of the existing observer. No change in legal or physical custody is ordered at this time. My lawyer nodded once, a small gesture of acknowledgement. He knew better than to push for an immediate shift. Family court moved deliberately, especially when federal interests were involved. Alexandra remained silent. Her shoulders had dropped slightly, and her hands, which had been flat on the table, now curled inward. She stared at the wood grain, as if searching for a rebuttal that wouldn't come. The fear that had flickered earlier had deepened into something heavier, worry that her own motivations might now come under scrutiny. The trust fund she had referenced so confidently, the recordings she had submitted, the years she had positioned herself as the reliable constant, all of it might be reframed if the court began questioning whether her petition was driven more by control of assets than by genuine concern for Haley. The judge addressed both attorneys. Counsel, you will receive copies of the CPS order and any declassified portions of the federal materials that the department authorizes for release. If additional sealed information becomes necessary, the court will reconvene in chambers. Until then, the parties are to maintain the current arrangement and refrain from any actions that could be construed as interference with the investigation or the child's routine. She paused again, her gaze moving between my sister and me. This is not a dismissal of the petitioner's concerns, nor is it an endorsement of the respondent's position. It is a recognition that the full picture is not yet before the court. The best interests of the child demand thoroughness, not haste. Mr. Reed finally spoke, his voice quieter than before. Your Honor, may we request a status conference in 30 days to review the CPS findings? Granted, the judge replied. The clerk will schedule accordingly. Any motions in the interim should be filed with proper notice. She gathered her papers. This portion of the proceeding is concluded. We will return to open session to adjourn formally. Bailiff. The bailiff opened the door. We rose as the judge stood and walked out first. The hallway felt brighter after the dim confines of chambers, but the weight in the air followed us. As we passed back into the courtroom, my daughter looked up from her seat. The observer had given her a coloring book. She held a crayon, loosely watching us file in. I wanted to smile at her to signal that things were shifting in a better direction, but I kept my expression neutral. Too much was still unresolved. Alexandra walked beside her attorney, steps slower than usual. She didn't look at me again. Whatever words she might have had earlier were gone. In their place was a quiet, growing apprehension, the realization that the court's scrutiny might turn toward her own conduct, her own reasons for pursuing this so aggressively. The judge re-entered the courtroom and took her seat. The court stands adjourned pending further investigation. The parties are excused. The gavel came down once sharp final. We filed out into the corridor. My lawyer walked close beside me. This buys time, he said quietly. The CPS report will be key, and with the federal confirmation on record, their evaluation will carry more weight. I nodded. Time. That was what I had now, time to let the truth filter through the system without rushing it. My sister passed us without a word. She kept her eyes forward, coat draped over her arm. For the first time, I saw uncertainty in her stride. The hallway emptied slowly. I lingered near the elevators, waiting for the observer to bring Haley out. When she appeared, small hand in the observer's, I knelt to her level. Hey, sweetheart, I said softly. She looked up at me, eyes wide, but not afraid. Is it over? Not yet, I told her. But we're getting there. We walked toward the exit together, the winter light slanting through the tall windows. Outside, Philadelphia was gray and cold, but the air felt different, less suffocating. P7. The agent gathered her portfolio with the same quiet efficiency she had shown throughout. She aligned the edges of the documents, closed the leather cover, and slipped it under her arm. Then she turned slightly toward me. Our eyes met for the briefest moment. She gave a small nod, professional, neutral, almost imperceptible, before walking past the table and out the side door without another word. The judge watched her go, then addressed the room. This concludes the in-chambers portion of the hearing. The court will issue a formal adjournment order in open session. Parties and counsel are excused for now. Further proceedings will be scheduled upon receipt of the required supplemental materials. She rose, robe rustling softly, and left through the door she had entered. The bailiff held it open until she disappeared down the corridor. We stood in silence for a beat. My lawyer placed a hand lightly on my shoulder. We'll get the formal order filed today. You're free to leave. Across the table, my sister rose slowly. Her attorney murmured something to her, but she didn't respond. She looked smaller somehow, the confident posture from the morning gone. As she passed me on the way to the exit, she hesitated. Her lips parted, then closed again. Whatever she had intended to say stayed unspoken. She walked out without looking back. Outside the courtroom, the hallway felt wider, colder. I waited near the elevators for the observer to bring Haley. When they appeared, my daughter's small hand in the woman's larger one, I knelt down. Ready to go? I asked softly. She nodded, clutching a folded coloring page in her free hand. The observer handed me a clipboard to sign, acknowledging temporary release under supervision. She'll remain with you until the next status hearing, but CPS will check in periodically. Any changes, call the caseworker. I signed, then took Haley's hand. Her fingers felt small and warm in mine. We walked toward the main doors together. The winter light outside was harsh, reflecting off the marble floors and the snow-dusted steps of the courthouse. As we descended the wide stone staircase, I glanced back once. My sister stood near the entrance with her attorney. She was speaking to him in low tones, gesturing sharply. Her face was tight, eyes narrowed against the wind. For a moment, our gazes locked again. Hers held no apology, no regret, only a quiet, simmering resentment. She turned away first. We reached the sidewalk. The observer followed at a discreet distance, protocol requiring supervision until the order was finalized. Haley tugged my sleeve. "Can we get hot chocolate?" I smiled down at her. "Soon. Let's get home first." The drive back to the apartment was quiet. Haley stared out the window at the passing buildings, the gray sky, the bare trees along the Schuylkill River. I kept my eyes on the road, but my mind kept returning to the courtroom, to the agent's nod, to my sister's silence, to the judge's measured words that had cracked open the case without resolving it. When we arrived at the building, the observer checked the apartment briefly, standard procedure, then left with instructions to call if anything changed. The door closed behind her. Haley kicked off her shoes and ran to her room. I stood in the hallway for a long moment, listening to her rummage through her toy box. The place felt different now, not safer exactly, but less empty. Her drawings were still taped to the fridge. Her backpack hung on the hook by the door. Small signs of life that had been absent for too long. I pulled out my phone. There were no messages from my sister. No calls. No texts. I opened the contacts list, scrolled to her name, and stared at it. My thumb hovered over the block button. I thought about the years she had cared for Haley when I couldn't. The school runs the bedtime stories, the birthday cakes she baked from scratch. I thought about the recordings she had submitted, the way she had framed every absence as proof of my failure. I thought about the trust fund she had mentioned so casually in court, as if it were the primary reason she had fought so hard. And I thought about the look on her face when the agent spoke, the color draining away, the hands going still. She had believed her version of the story. She had convinced herself that stepping in made her the better option. But somewhere along the way, the line between protection and possession had blurred. The inheritance, the control, the quiet satisfaction of being the reliable one, it had all become part of her motive. I pressed the block button. Then I did the same for her email, her social accounts, every channel she might use. No call, no text, no meeting, no forgiveness. The betrayal had cut too deep. It wasn't just the custody petition. It was the way she had used my silence against me, turned my sacrifices into evidence of neglect, positioned herself as the savior while quietly positioning for control of Haley's future. That kind of betrayal didn't heal with an apology or a conversation. It left scars that didn't fade. I put the phone down and walked to Haley's room. She was sitting on the floor surrounded by crayons and paper. She looked up. "Mommy, draw with me." I sat beside her. "Yeah. Let's draw." We colored in silence for a while. Her hand moved in careful strokes, filling in the lines of a house with a big sun overhead. I added a tree, then a swing. Simple things. Safe things. Later, when she was asleep, I stood in the doorway watching her breathe. The room was quiet, except for the soft hum of the heater. Outside, the city lights flickered through the blinds. I didn't feel triumphant. I didn't feel vindicated. I felt tired and resolved. My sister had crossed a line that couldn't be uncrossed. Whatever came next, the CPS visits, the status hearings, the eventual final ruling, I would face it on my own terms, but I would not face it with her. The door between us was closed, locked, and I had thrown away the key. P8. Haley's hand felt small and steady in mine as we stepped down the cold stone steps of the Philadelphia courthouse. The northeast wind cut through my coat, sharp and unrelenting, carrying the faint salt of the Delaware River and the distant hum of traffic on Broad Street. The sky was a flat, unyielding gray, the kind that made the city feel smaller, more enclosed. I walked slowly, matching her shorter strides. She didn't speak much, just pointed at a pigeon strutting across the plaza and asked if it was cold too. I told her yes, birds feel the wind the same way we do. She nodded solemnly, as if filing the information away for later. Behind us, the heavy doors of the building had closed with a finality that still echoed in my chest. Inside those doors, the case had been paused, not resolved. The judge's words lingered: further investigation, supplemental reports, best interests of the child. But outside in the open air, the real consequences were already settling. My sister had left before us. I had seen her silhouette disappear around the corner of the building, coat pulled tight, head down against the wind. She hadn't said goodbye. She hadn't looked back. Whatever conversation she might have imagined having with me never happened. The space between us had grown too wide, filled with too many unspoken accusations and too much damage that words couldn't repair. I thought about the years I had spent in the shadows of the program, the late-night briefings in windowless rooms, the false identities, the constant calculation of risk. Every time I disappeared, I told myself it was for something bigger: cases that stopped money laundering rings, that dismantled networks trafficking people across borders. I told myself the sacrifices were necessary, that one day the work would end and I could explain everything to Haley, that one day my sister would understand. But understanding never came. Instead, she had turned those absences into ammunition. She had collected evidence of my unavailability, framed it as neglect, and brought it to court with the conviction of someone who believed she was saving a child. Perhaps she did believe it at first. Perhaps the role of the steady aunt had felt righteous. But somewhere along the line, the trust fund and the control it represented had shifted the balance. The line between protecting Haley and possessing her future had blurred until it disappeared. I didn't hate her. Hate would have been simpler. What I felt was something colder: disappointment so deep it had become detachment. The betrayal wasn't just the petition. It was the choice to weaponize my silence without ever asking why it existed. She had assumed the worst because it fit the story she wanted to tell. And in doing so, she had broken something that couldn't be rebuilt. Haley squeezed my hand. "Mommy, are we going home now?" "Yes," I said. "We're going home." We crossed the street and walked toward the parking garage. The wind pushed against us, but we kept moving. Behind us, the courthouse receded, its columns and steps fading into the gray afternoon. Ahead, the city stretched out, streets lined with brick row houses, the Schuylkill River glinting under the bridges, the distant outline of Center City towers. I didn't know what the next hearing would bring. The CPS report might favor me, or it might raise questions that took months to answer. The federal materials might remain sealed forever, or parts might surface in ways I couldn't predict. But none of that changed the decision I had already made. There would be no calls to my sister, no messages, no tentative attempts at reconciliation. The bridge she had burned was gone, and I wouldn't rebuild it. Some ruptures were permanent. Some wounds scarred over but never healed completely. Family wasn't always forgiveness. Sometimes it was recognizing when the cost of keeping someone close outweighed the pain of letting them go. Haley tugged my sleeve again. "Can we stop for ice cream?" I laughed, the sound surprising me. "It's freezing out here." "I know, but ice cream makes everything better." We stopped at a small shop on the corner. She chose chocolate with sprinkles. I got coffee. We sat on a bench outside, coats zipped tight, watching people hurry past. She ate slowly, savoring each bite. I watched her, memorizing the way her nose wrinkled when the cold hit the ice cream. This was what I had fought for: not victory in a courtroom, not vindication from a judge, but these small moments. A child's hand in mine, a shared cone on a cold day, the quiet certainty that I was here now and I would stay. My sister would face her own consequences. The court might question her motives. The trust fund might be scrutinized. Her role as the reliable caretaker might be reframed as something more self-serving. Or perhaps none of it would matter, and she would continue believing she had acted in Haley's best interest. Either way, it was no longer my burden. As we finished and walked toward the car, the wind picked up again, swirling dry leaves across the sidewalk. Haley skipped a little ahead, then turned back to me with a grin. "Race you to the car," I let her win. She laughed as she touched the door first, triumphant. We drove home through the city, the radio playing softly. The sun was low now, casting long shadows across the streets. In the rearview mirror, the courthouse had vanished behind us. There was no grand resolution, no tearful reunion, no promise that everything would be okay. There was only the road ahead, the small hand resting on the console between us, and the knowledge that some truths come too late to save what was lost. But they come in time to protect what remains. And that, I realized, was enough. The story ends here, not with healing, but with acceptance. With the understanding that betrayal from family cuts deepest because it comes from trust. That silence can be both sacrifice and shield. That sometimes the strongest thing you can do is walk away, not out of anger, but out of self-preservation. For anyone watching this, if you've ever felt the weight of a family rift that won't mend, know this: you are not alone. The pain is real. The distance is real. And choosing to protect your peace isn't weakness, it's survival. Sometimes the most loving thing you can do for yourself and your child is to close the door and keep walking. In my opinion, family isn't defined by blood or obligation. It's defined by who shows up consistently, who respects your boundaries, who doesn't turn your sacrifices into weapons. When that trust breaks, the pieces don't always fit back together. And that's okay. You build new ones. Haley and I kept walking, into the cold, into whatever came next, together.